Welcome to everyone. It's great to be with you on another Tuesday at noon, something we've been doing for the past 2.5 years. So welcome, great to see you all. Okay, so first we're going to start off, we got a packed program, but we're going to start off with my normal COVID update. Kathy, next slide, please. On the first slide, I put a comparison of the last 90 days in New York State with the timeline from the beginning of the COVID pandemic. It's quite interesting to look at. You can see we had our major spike last winter, but that burned up very quickly, and we dropped pretty low in April of 2022. We saw a little bit of a spike there come June, beginning of part of July, but as you can see, we've entered into another downtrend. The numbers for this month are pretty good. The daily average as of August 29th is 4,482 cases. That's a 13% decrease over the past 2 weeks. We're seeing hospitalizations go down, ICU numbers and deaths all going down. So we are trending in the right direction at this point as it relates to COVID. In New York State, I should say. Next slide, please. Again, we're looking at these helpful color-coded charts that we show you every couple of weeks. Light orange is good, dark orange and red are bad. We are mostly in the light orange color throughout most of New York State. Even New York City, which had been experiencing a little bit of a spike, has toned it down a little bit. So that's really good. You can see that the only county where we're seeing some significant increases are Schoeneck County and Tioga County. Schoeneck County, the numbers are a little bit deceiving because the daily average of cases is 16. So we're not talking about a huge number of cases, but because the population is relatively small, that's a significant number or significant increase. So those are the current numbers, all good things. We've seen only reductions or lessening of COVID restrictions over the past couple of weeks. We saw the CDC reduce its COVID precaution restrictions. Hopefully New York State follows suit shortly. But we're in pretty good shape as it relates to COVID at the current time. So we will continue to provide these updates to you on a weekly and bi-weekly basis, if not bi-weekly basis. But that's where we are for now. Okay, now let's move on to the substance of today's discussion. First off, I am very pleased to welcome Candace Gomez. Candace is a member in our Garden City office who primarily practices in the school law group. She is, I believe, Candace, you're the chair or co-chair of our school law practice group. So Candace, welcome, great to see you.
My name is Candace Gomez. I'm a co-chair of our school law practice group along with Kate Reed. Our practice group is privileged to represent many public school districts and private schools on the K through 12 level throughout New York State. And as you can imagine, this is a very busy time of the year and a very exciting time of the year for our clients as we prepare for a new school year. In preparation for the start of this new school year, Governor Hochul and the New York State Department of Health released updated COVID-19 guidance. And the governor and Department of Health have stated that the updated New York State guidance is intended to more closely align with the updated CDC recommendations. So according to this updated guidance that we've received, if a person is asymptomatic but tests positive for COVID, then they must quarantine for 5 calendar days after testing positive. And they will then be permitted to return to school on days 6 through 10. And both New York State and the CDC recommend that the person wear a well-fitting mask during school on days 6 through 10. But we do want to point out that the mask wearing is a recommendation. It's not a requirement. So what we expect to see is probably many variations in how different school districts and how different individual school buildings perhaps may be handling the masking situation, because of course the level of which they choose to implement it may vary as we look school by school. If a person is symptomatic, then they must quarantine for 5 calendar days after they begin having symptoms. and they will then be permitted to return to school on days 6 through 10, provided that they are fever-free and their symptoms are improving. And as we previously stated, mask wearing is recommended on those days 6 through 10, but it's not a requirement. So there will be some variations in how schools choose to implement the mask recommendation. When it comes to employees, as the guidance currently stands, employees will be permitted to use paid COVID leave up to 3 times during their lifetime. And once that COVID leave time is used up, then the employee would need to use their sick time for any further days that are taken off. So we are keeping a close watch on further information that we may receive from New York State, not only regarding COVID, but also regarding the monkeypox outbreak and the measles outbreak. And we're keeping our fingers crossed and hoping that this is the start of a safe school year of in-person instruction and a relative return to normalcy for our students and staff in this upcoming school year. So thank you all for your time, and I will turn it back over to Adam at this point.
Candace, thank you so much. Okay, next up, we have Krista Cook. Krista is a member in our Syracuse office in the Labor and Employment Department. Krista has some exciting updates for us relating to OFCCP. So Krista, thank you.
Thanks, Adam. Hello, everyone. Thanks for joining us. I think Adam's being generous when he says I have exciting developments to share with you, but they are important. So OFCCP, which enforces the laws governing federal contractors, OFCCP has been extremely busy in 2022. They've announced numerous initiatives signaling their increased and more aggressive enforcement throughout 2022. So we want to keep all of you informed of these developments. Many of you probably have heard in previous webinars. I've been on this webinar before, talking about the OFCCP's contractor portal that the OFCCP uses for federal contractors to certify their compliance with affirmative action mandates. There's been an unusual number of directives issued by OFCCP, including a pay equity directive. They've announced changes to their investigation and audit compliance practices. So I want to just share with you a few of the recent developments. The next slide. So the first one we wanted to bring to your attention is an issue with OFCCP potentially disclosing employer EEO-1 data. The OFCCP, again, is responsible for ensuring that federal contractors comply with laws and regulations that prohibit discrimination. And in some cases, depending on the nature of the federal contract and the circumstances of that contract, the employer may be obligated to engage in written affirmative action plans. So with employers with 100 or more employees are required under Title VII to file an EEO-1 report annually. Again, that is Title VII and has nothing to do with OFCCP. However, in addition, employers with 50 or more employees that hold prime or first tier federal contracts are also required to file EEO-1 reports annually, even if they have less than 100 employees. So all of these EEO-1 reports are submitted into the EEOC. The EEOC maintains this data. The EEOC shares the lab reports with OFCCP. Hopefully, it's intended that the OFCCP is only receiving the EEO-1 reports for employers that are in fact federal contractors. Now, the EEO-1 report generally contains employee data for employees company-wide by job category, including their employees' sex and race. As all of you know, probably that EEO-1 report doesn't name any individual employees' names. It lists the report lists the employee's workforce by gender and race, but through a job categorization. So by law, and then the EEOC must keep these EEO1 reports confidential. And that is mandated by Title VII. Section 709 of Title VII requires the EEOC to keep this and other types of information that it gathers as confidential. And in fact, EEOC personnel are subject to criminal sanctions for failing to do so. So the EEOC takes that pretty seriously. No such legal mandate prohibits the OFCCP from making these types of data and reports public. And the reason for that, again, is that the statutory mandate to keep it confidential expressly applies only to the EEOC and the EEOC personnel. And so all of these confidentiality rules, or in the case of OFCCP, the lack of any rules, this applies to requests pursuant to FOIA. Next slide. So on August 19th of this year, OFCC published a notice in the Federal Register advising all employers that they received a Freedom of Information Act request, a FOIA request. That FOIA request was sent or submitted by an entity called the Center for Investigative Reporting. The CIR, Center for Investigative Reporting, is not new to these FOIA requests. They've made FOIA requests at OFCCP in the past. And in fact, CIR has engaged in litigation with OFCCP about these FOIA requests. So in August of this year, OFCCP notified all of you that they received this FOIA request. The request is specifically for Type 2 consolidated EEO1 data for the years 2016 to 2020. And the intent or the purpose of the notice in the Federal Register is to advise employers that they have until September 19th, if they wish to do so, to file written objections to OFCCP in order to convince OFCCP not to disclose their EEO1 reports. Those written objections can be submitted by mail. They can be submitted in an online portal. OFCCP has a website dedicated to this issue, and they've created an online form specifically for these objections. Or you can submit objections via mail to the address that's on the slide. So to give you an idea of what that, these written objections should be, under FOIA, the OFCCP is obligated to respond to a FOIA request unless there is a specific exemption that allows them to withhold the documents. Here, the potential exemption is exemption 4 that protects confidential commercial information from being disclosed. The next slide. So any employers that are concerned about the potential disclosure of this EEO1 data, they can do a few things. We want you to know that you can contact OFCCP in the method or manner that was on the previous slide, doing a few things. You can inquire whether the EEO1 data, whether your company's EEO1 data is included in this plan disclosure. You can request a copy of the information that OFCC plans to disclose so that you actually see what the data is and that you can see that it is in fact responsive to the FOIA request, or perhaps it's beyond and more broad than the FOIA request, and then you can raise that objection. And third, really to submit a written objection that your company opposes or objects to the disclosure of this data at all. The OFCCP has said that they will, if an employer does not submit written objections, they will assume you have no objection, and they may very well disclose the EO1 data for your company. If you do submit written objections, they will take it into account, but it will not guarantee that your data won't be disclosed. So there's no promises, but it certainly places a lot more pressure on OFCCP if you submit the objections. Now, some employers have released these type 2 reports publicly. I don't think it's been a lot, but there are organizations that have disclosed this, in the interest of showing their diversity of their company. If a company has done that, I don't think they're going to have any grounds to object to OFCCP's release of that same data, because you have chosen not to keep that data confidential. I want to also just raise that although this really is something that federal contractors need to think about and decide for themselves whether they want to, go ahead and file these written objections, this is also, potentially could impact non-government contractors, because OFCC is believed to have EO1 reports for many non-government contractors, which it likely could release and may release pursuant to this FOIA request. And the reason for that is a few things. The most obvious, or the biggest one, is that the EO1 report asks, in a certain question of the EO report, in question 3 of the report, asks a series of questions to determine if your company is in fact a federal contractor. The question is drafted horribly and it's very confusing. It leads to many employers answering it wrong. And as a result, the EOC is potentially, most likely, disclosing your data to OFCCP when you in fact might not be a federal contractor. That often happens with instances where the parent company is submitting the EO1 report on behalf of subsidiaries. Some may be federal contractors, some might not be federal contractors. The way in which the system works, it's very difficult to delineate which ones are and which ones aren't. So that does raise some concerns about what data OFCCP has and what might be released. Okay, next slide. Another issue that we want to alert you to is, and this is a less significant issue, it's more giving us an idea of where the OFCCP is going. The OFCCP has recently created a new construction contractor award portal. Just on August 26th. So it's brand new. They launched this new online platform. The intent of the platform is to allow employers who have been awarded a federal construction contract or as a subcontractor for a federal construction contract to notify OFCCP about that construction award. The portal itself is referred to as the Notification of Construction Contract Award portal, that NCAP. If you go on their website, they have a lot of information, FAQs and technical information about this new portal. So again, the point of this new contractor award portal is to allow employers potentially a more efficient way to notify OFCCP, because they have to notify them within 10 working days of award of a federal or even a federally assisted construction contract that exceeds $10,000. That is not a new requirement. This contractor award portal is simply a new way to provide that notification. Next slide. The reason we want to bring it to your attention is not only might be more convenient for you to use the portal, OFCCP is encouraging federal construction contractors to do so, but to alert you to the fact that, not surprisingly, we always are leery of this is just for your convenience, right? I have some doubts about that. The OFCCP will use this information, they have said, to more quickly and more efficiently on their side of the spectrum to schedule construction contractors and subcontractors for compliance evaluations. So they're really using it on their end to get to employers to send out audit and compliance review information. Last thing I wanted to mention is the OFCCP launched, as I mentioned before, a federal contractor portal earlier this year. And I shared some of that information on the webinar back a while ago. Contractors that are only construction contractors and not also supply and service contractors are not required to certify compliance on OFCCP's contractor portal. I think there potentially may be some confusion about all these portals. This construction contractor portal is simply for construction contractors to notify OFCCP they've gotten a new contract award. This doesn't mean that construction contractors now have to go register and certify on the contractor portal, and you shouldn't. Okay, next slide. So the last issue that I wanted to bring to your attention is a development regarding OFCCP's controversial pay equity directive. In March of this year, we covered this directive, 2022-01. That was the number of the directive. And that directive indicated, really for the first time and without any backing from any regulatory standpoint, that federal contractors are required to conduct statistical pay equity audits on an annual basis. Okay, there were a lot of concerns about this directive. I was on the webinar back in March and shared with you some of those concerns. We were concerned that OFCCP had really overstepped in this in that directive. Well, in response to pushback from the contractor community, OFCCP revised its directive and recently issued a new directive clarifying that the compensation analysis that its regulations require federal contractors to perform is not necessarily a statistical regression analysis, which is really what they said in the first directive. So the revised directive is pulling back and saying, okay, well, we use the term pay equity audit. Really, it's a compensation analysis. And, in the slide, I've listed some of the stuff that the revised directive states that employers, federal contractors must do at a minimum. OFCCP shared in this new revised directive that they prefer employers to do a pay equity audit every year. But of course, it's not legally mandated, and it's time consuming and costly. So it is welcome news that they are not trying to implement a new pay equity obligation on federal contractors. I would warn you, though, that the language in the new directive doesn't necessarily pull back as much as we'd like. Next slide. And so we want to just keep in mind that, despite walking back on certain of these points, this is very much an OFCCP's attention. It's a focus area for them. They have also said that they have abandoned their prior position that they want a complete copy of the contractor's quote unquote pay equity audit or analysis. And now have said that there are ways that they will allow employers to maintain the privilege, attorney-client privilege of those reports, or to even submit a detailed affidavit describing your company's compensation analysis efforts. So they've walked back some of that to allow employers to maintain the confidentiality, particularly that they're having with their counsel on these types of pay equity audits. But they're not relaxing their focus, and we do anticipate that compensation and many other issues are going to be at the forefront of OFCCP's efforts over the next throughout the remainder of 2022. We expect more frequent supplemental information requests, we've seen in compliance reviews. So OFCCP is in action, and we just wanted to bring these developments to your attention. Thank you.
Awesome. Thank you, Krista. Before we move on to the next topic, there are a couple of questions in the Q&A that I want to address. We've seen a number of questions about the conflicting guidance between the CDC and New York State Department of Health regarding quarantine. So as I'm sure you're all aware, the CDC removed the quarantine requirement for those who are exposed or have close contact with someone with COVID-19. The state guidance still has a quarantine requirement for those who are not up to date on their booster. So there is a conflict at this point. The state DOH has not updated its guidance. And so if you'd like to discuss, which guidance that you should be following, I think there are pros and cons, and you should talk about that with your attorney. The other theme that we're seeing in the Q&A deals with COVID paid leave. We've talked to you quite a bit about COVID paid leave. According to the guidance from the Department of Health and Department of Labor, that leave is available up to 3 times period. It's not 3 times per year, it's just 3 times. So if your employee got COVID 3 times in the first year, used the COVID paid 3 times, they don't have any left. So yes, there's a 3-time limit on COVID paid leave. All right, moving on. Another interesting topic, updates on New York's healthcare worker bonus program. This is something that is very, very important to our healthcare clients. And here to talk about it is Kat Grazios. Kat is an attorney in our Albany office and has been following this issue closely. So Kat, welcome.
Thanks, Adam. As Adam mentioned, I'm Kat Grazios. I'm part of our healthcare and higher education practice groups here at Bond, and I'm here to talk about the updates to New York's healthcare worker bonus program. The program dropped August 3rd. We knew about it from this past year's fiscal budget, but it dropped August 3rd, and there's been a lot of confusion since then. So the state has been holding these weekly town halls. The first one was August 19th, the most recent one, August 26th. With each town hall that they host, the state updates their FAQs, and so I'm here to speak to some of the updates to the FAQs. Next slide, please. So the first issue I'd like to talk about is the correction to the employer eligibility. The state clarified which employers are eligible. Initially, still now, it's an element test. You have to meet all 4 of these elements in order to be a qualified employer. And so first, you have to be a Medicaid enrolled provider. You have to bill Medicaid services through fee-for-service, managed care, or 1915C waiver. And I should say that this is separate and apart from Part W2C, which we're hoping to get some more guidance on in September. Going further on the list, Part 3, they employ at least 1 eligible employee. And now the latest update has to do with Part 4. Initially, Part 4 was broken down into multiple subparts, and you had to meet each one of the subparts in order to be an eligible employer. The state updated their guidance by providing for those ORs, which I've highlighted. Now you just have to meet one of the 3 subparts to Part 4, in addition to the other 3 elements in order to be an eligible employer. So it looks like the department is no longer strictly adhering to the list of employers in the statute. As we may know, in the statute, they listed Article 28 facilities, Article 30 and 36 facilities, for example. And if you didn't fall into one of those strict lists, it was pretty unlikely that you were going to be an eligible employer. Now, and most importantly, which is bolded on our slide, if you're an employer that serves at least 20% Medicaid population, as long as you meet the other 3 criteria that are up on the slide, you're going to be considered an eligible employer. And so many providers are finding themselves under this Part 4C provision. So now there's a whole new boat of individuals who are going to be eligible employers and that this healthcare worker bonus program applies to. Next slide, please. Another important update is that contract employees are now eligible. There's some conflicting guidance within the state FAQs that are up right now. There's an old guidance saying that contract employees are not eligible. State seems to be walking this back, and now contracted employees are eligible. This came up pretty frequently in the COVID-19 pandemic, resulting in the staffing crisis. And so a lot of provider facilities saw themselves contracting with third-party entities and PEOs to provide them with supplemental staffing services. So now you have these individuals in your nursing facility or in your hospital or other eligible facility that half of them may be employees that you as the provider are employing, and the other half may be contracted employees. And initially there was this issue with whether one half was receiving the bonus and the other half that was contracted wasn't. The state saw this issue and decided to walk this back, and now there's new guidance saying that if you are employed by the contracting agency, you're going to be eligible. This created the issue of who's going to be paying the bonus. You have this provider facility who is billing to Medicaid and eligible for the bonus, and you have the contracting employer who is not likely billing to Medicaid and likely would not be eligible. So who's paying the bonus? The state decided that the provider facility would be responsible for paying the bonus. Even though the provider facility is not the employer for pretty much any other purposes, healthcare, for employment benefits, other employment issues, for the strict purpose of this bonus, the facility is going to be considered the employer. Let's see, next slide, please. This is a more minor update, but the state took the time to note that individuals that are in management or supervisory roles are not automatically precluded from receiving this bonus, so long as they are otherwise eligible. So merely being a nurse supervisor or something is not going to restrict you from getting this bonus, even though your patient contact may not be as much as those individuals you're supporting, you're still going to be eligible. On the flip side, the state also clarified a bit with the healthcare support worker provision. In quotes, they said, for healthcare support workers to be eligible, they must provide patient-facing care provided within a patient care unit or a hospital or another Article 28 institutional medical setting in support of treating and caring for patients. So there's still a lot of uncertainty with regard to healthcare support workers. The state clarified a little bit, saying that it's those healthcare support workers that are supporting, treating, and caring for patients. Next slide, please. And we've received a lot of questions on this one, so I'm going to do a brief analysis on the former employee issue. I do have to give credit to the state for this chart. I did just change the color, but this is their chart. I'm just going to explain it a little bit. So there's a few factors to look into when you're assessing whether a former employee is going to be eligible for the bonus. You need to assess whether the employee left on their own volition or were they terminated, when they left, and when they were terminated, and that matters, that distinction, and also when the employer has applied for this claim or made this claim for the bonus. Employers may be obligated to pay former employees that are eligible and vested while in their employment, provided the employee did not terminate his or her employment with the employer prior to the due date for payment of the bonus. I'm going to just run through real quick each of these factors. So, you have the typical run-of-the-mill, your employee is vested, they're still your employee at the time of the claim, the employee continues to be employed throughout the period and throughout your payment period, they're receiving the bonus. Then you have the issue of the employee has vested and they were employed when the employer made the claim. And interestingly and importantly, once the employer has been paid the claim by the state, they have 30 days to pay that out to the employee. Now, if the employer if you're in that 30-day period, the employer fails to pay the bonus within that 30 days and the employee leaves on their own after that 30 days, you still have to pay them the bonus. If the employee is vested and before the employer submits the claim, the employee is terminated. So now we're talking about before that 30-day period even began. We're just talking about the claim period, but the employee has been terminated. You still have to pay them the claim. And that's different than if the employee left. If the employee had left on their own in that time, you wouldn't be on the hook to pay the claim, pay the bonus program payment. But now you do have to pay the payment. Next slide, please. So it gets a little more confusing too. So if you have the employee has vested, was employed at the time that you as the employer submit the claim, and then the employee is terminated by the employer, they're eligible to receive that payment. I said that before, and that's just the state, explaining that further there. Now we're getting to the examples where the employee is not eligible for the bonus. So you have the employee has vested, but the employee quits prior to the employer bringing that bonus claim, not eligible. The employee is vested, was employed at the time of the claim, but the employee left before the employer received the bonus payment. So that's before that 30-day period even started. They're not going to be eligible. And then the final one, the employee has vested. They're employed at the time of the claim and when the employer received the payment. And now we're in that 30-day period that the employer has to pay this claim out or pay this bonus out to the employee. and the employee leaves on their own volition, they are not going to be eligible to receive the bonus payment. So that's the basic breakdown of how this applies to former employees. Next slide, please. And also, since we have our first deadline coming up this Friday, September 2nd, the state has offered a grace period for those that make a good faith effort to meet this deadline, but are still unable to meet it. Employers should make every attempt to submit the claims for the vesting period 1, which, as I stated, ends this Friday, and as soon as the employee is eligible. The employers still must validate that employees met all the qualifying criteria during the applicable vesting period. The healthcare worker bonus portal, interestingly, is going to be closed from September 3rd to September 30th. So there's not much that can be done in that time period as far as submission goes anyway. But then the portal opens up again October 1st. And this is the important deadline for those that aren't able to meet that first vesting period. You now have an opportunity, as long as you made a good faith effort to meet the first vesting period, you can apply in that second vesting period for retroactive payback applying to your first vesting period. Similarly, Department of Health is going to recognize employer good faith with regard to complying to the September 2nd deadline. And what that means is that so long as you've made a good faith effort to comply with it, they're going to allow for applicants to clean up any filings at the close of the next vesting period window, which is that October 1st to October 31st window for vesting period 2. Next slide, please. And I just want to talk briefly about enforcement. So you may be wondering, will the employer's determination of employee eligibility be subject to review? And yes, it will be by the Office of Medicaid Inspector General, by the state, etc. So what if I'm a qualified employer but do not apply for the bonus on behalf of my eligible employee? Well, the punishment includes up to exclusion from the Medicaid program, which is pretty devastating to those programs that rely on it. Many programs do. You may also be subject to penalty. What we've seen so far is that the penalties range around $1,000 per violation. That is in line with the bonus payment that's being paid. So in addition to general penalty, you may be excluded from the program. So it's important to apply to this program if you're eligible. Next slide, please. And finally, I just wanted to break down a few scenarios with regard to enforcement and penalties. And, you know, there's a lot of uncertainty here. So there's going to be mistakes made. And so what are the repercussions for making those mistakes or in good faith? So if an employer applied for a bonus for an employee that's not qualified, well, the employer is going to have to pay it back to the department. If an employer fails to pay a healthcare worker bonus claim and received on behalf of the employer remains liable to pay the bonus regardless of sanctions or penalty imposed by OMIG. So if you're an employer, you receive that payment from the state, you just didn't dish it out to your employee, you're going to have to do it, or you're going to be penalized for it by OMIG. And then finally, some individuals that are receiving this bonus payment may be wondering, what if I receive this payment and I wasn't supposed to? Will OMIG be coming after me for remittance of this payment? And the answer is no. According to the state, the answer is no. Once paid to the employee, the payment stays with the employee. The employer is responsible for remuneration to the state. And the employee may be wondering, well, can my employer take the money back for me? And the answer to that, again, is no. The employer should not be taking any bonus payments back from the employee, even if erroneously made, according to the state. And with that, I would like to turn it back to Adam. Thanks so much for having me here.
Kat, awesome job. Thank you very much. That's a lot of information. We know that. These slides will be sent to you via email in the next couple of days, as they typically are, but you will also be able to access them on our website. I know somebody asked that question. There were a lot of very specific questions in the Q&A section. Those are great. If you have very specific questions, reach out to Kat. She is happy to answer those questions. I know she is. And hopefully we can get you the help that you need in completing your applications. All right, next up, we had what was going to be a riveting presentation from Lou and I about not discipline and discharge. So I'm glad that we're not gonna be able to do it, but about defamation in the employment context. Lou and I have both had a number of cases recently dealing with defamation and how that can impact you as an employer. What I'm going to do is tease that presentation for the next time I am on. Lou and I will do that together, and you'll all just have to hold your breath, and we'll see you next time. With that, I am going to close the webinar for the day. Great to see you all. Thank you for being here, and we'll see you next Tuesday.